In Arizona, insurance policies are considered contracts. Personally, when referring to insurance policies, I use that term very loosely because realistically, insurance policies fall in line with contracts of adhesion. Simply calling a document a contract implies that both parties to the agreement had a fair and an equal opportunity to negotiate with it. However, with an insurance policy, that's not the case. Contracts of adhesion are ones in which one party to the contract has complete power and authority to be able to outline the terms and conditions of the insurance policy, and the other party basically has two choices. They can take it or they can leave it. There is no equal opportunity to negotiate the terms and the conditions. Insurance policies are exactly what that is. But just like any contract, both parties are going to have obligations that they're required to perform and comply with in order to not be in breach with the contract itself. In this particular series, I'm going to be discussing an insured's obligations to the insurance company. Aside from the obligation to pay the insurance company the premiums to the insurance policy, one of the first obligations that an insured owes to an insurance company is to provide notice of any potential claims. In order to allow the insurance company to perform an adequate investigation and obtain full information about the circumstances surrounding a claim, notice has to be given, and typically an insurance policy is going to require that it be given as soon as practicable. Following the notice given to the insurance company, insureds must then take certain actions, or in some cases must refrain from taking certain actions to preserve their rights of coverage under the insurance policy. For example, most liability insurance policies require that after a notice, an insured must cooperate with the insurance company's investigation, the defense, settlement, and other aspects of the investigation. A lack of cooperation by the insured, in some cases, may prejudice the insurance company, which then in return may deny the insured coverage under the insurance policy. Some first-party coverage provisions may require that the insured provide proof of their loss, or that the insurance company be given access to certain books, records, or within reason, other materials that the insurance company believes is important to their investigation. In other cases, insured may be required to submit to an examination of some kind. For example, a medical examination to a doctor of the insurance company's choosing. As the last example, if the insured is alleged to have caused injury or damage to somebody else, then the insured is going to be obligated to send any demand letters or lawsuit documentation that they receive as a result of the claim negligence. Now, the insured also has an obligation not to enter into any unauthorized settlements with the injured party. Unauthorized settlements basically means anything that the insurance company has not authorized. So in the next series, I'll be discussing the insurance company's obligations to the insured under the contract. As always, please keep in mind that the concepts shared here are general in nature. If you have specific questions to your specific situation, please call Curry, Pearson, and Wooten for a consultation.